Moja tunataka kuelekea katika mahakama ya rufaa ambapo kuna kesi inayosikizwa kuhusiana na usambazaji wa bia katika maeneo mbalimbali hapa jijini Nairobi. Tetesi zimeibuka kati ya kampuni ya Bia Tosha pamoja na kampuni ya East African Breweries kuhusiana na sehemu 22 ambazo Bia Tosha inasema kuwa ilikuwa na mkataba na East African Breweries ya kuweza kusambaza bia hizo, na wangependa kuwa mkataba huo usalie jinsi ulivyokuwa, lakini EABL ambayo ni East African Breweries wamekuwa wakisema kuwa mkataba huo ulikuwa unapaswa kuwa wakisema kuwa mkataba huo pia ulijumuisha wasambazaji bia wengine kwa sababu Bia Tosha ilishindwa kusambaza video hivyo katika maeneo ambayo yametajwa kwenye mkataba. Hebu tusikize.
Page 263, in the affidavit before the landed judge, the appellants placed material before the judge showing which routes had been taken away and which distributor was servicing those routes in terms of supply of the appellants' products. That affidavit, my lady, was in support of an application for setting aside of the interlocutory orders previously given by the judge. But you'll notice at page 849, line 10, that the judge directed that that application be argued in response to the application filed by the first respondent. But material was placed before the judge showing that the routes that the appellants was referring to were already being served by somebody else. And therefore the finding by the judge was wrong, because he failed to take into account material already placed before him. And my lady, this will just amplify by saying this, that at page 799 and page 800, the learned judge actually acknowledged that the routes allocated to Bia Tosha were repossessed. The judge actually acknowledged. So if he had taken this account when arriving at his final decision, he would definitely not have met the orders that he did. Malana Senior has taken my ladies through the arbitration clauses in the various agreements, and all I can say, my ladies, is that in the face of those clauses and signature by the parties signaling their election to go for arbitration, the provisions of Section 6 of the Arbitration Act applied, and the learned judge ought to have allowed this matter to proceed in the manner that they said. And my ladies, I also want to refer my ladies to the decision of New2 Agrovet versus Airtel. It is the Supreme Court decision which has settled quite a number of matters on this issue. And my ladies will notice that under that decision of the Supreme Court, it says that what limits the jurisdiction of the Superior Court in arbitral proceedings is Section 10 of the Arbitration Acts. And you'll notice, my ladies, because of limitation of time, I won't take you through it, but my ladies will read it. It specifically says you cannot, by ingenuity, try to bring your case to fall under the Constitution. When parties have agreed to go for arbitration, you cannot now use the Constitution as a basis for avoiding going to arbitration. The next thing, my ladies, that I need to say is this. In his judgment, the learned judge specifically found that there was no high-handedness on the part of the appellants or the third and fourth respondents. He made that positive finding. There is no cross-appeal filed by the first respondent in respect of that finding. My ladies will find that finding at page 835, paragraph 129. And so when the first respondent now says their case is about unconscionability, high-handedness, and so on, those arguments cannot fall from their lips because they never filed a cross-appeal. Now, the following quick points that my ladies I think are important to make are as follows. From what my learned senior has said, the agreements entered into by the parties expired by a fluxion of time. And so the first respondent has taken the full benefit of the distribution agreements it entered into. It cannot now try and fault agreements after it has taken the full benefit of those agreements. The second thing, my ladies, is that although this is an interlocutory appeal, there is a danger that, my ladies, I think is important to note. The refusal by the learned judge to send the parties to arbitration as agreed between themselves has final consequences. And therefore, my lady, as regards that decision, is critical that the decision of the learned judge be set aside, because its consequence is not that, is the consequence that the route elected by the parties has been shut out from them. Quickly, my ladies, let me just say that there is nothing placed before the court to show that there was any...
5 minutes?
Yes, my lady. Yes. But there's nothing to show, my lady, that there was any trading between the parties, these specific parties, prior to 2nd of February 2006. No material has been placed, and that there is no agreement that has been placed before you, from what the respondent is saying, that has anything to do with UDV. Even the letters that they're talking about, there is nothing to show that there was a relationship with UDV. And so for those reasons, my ladies, the decision rendered by the learned judge, apart from being wrong and based on wrong, and proceeding on the wrong basis, even from a proportionality point of view, was the wrong decision, because what it preserved, my ladies, is not what even the parties themselves had sought before it. So from a proportional point of view, what should have been reserved should have been the money paid as alleged goodwill at best. And so, my ladies, for those reasons, we urge you to allow the appeal, set aside the judgment by the learned judge, and allow the parties, my ladies, to proceed on the basis on which they agreed in the agreement.